Okay, let's get right into it. This all starts with a story about a lawyer, a judge, and one single explosive letter. A letter that would climb all the way to the Supreme Court of Canada and completely change how we think about free speech versus professional duty.
So this was the lawyer, Gilles Doré, basically trying to draw a line in the sand. He's saying, hey, I'm not writing to you as an officer of the court. This is personal, just one man to another. He felt the judge's criticism of him in court was personal, so he believed his response should be seen the same way. But oh boy, the legal system, it was going to see things very differently.
So what on earth could a judge say that would provoke such a fiery, personal clapback? And maybe more importantly, how did this one private letter manage to ignite a national legal battle that questioned the very nature of free expression in Canada?
Wow, okay, so just look at the language here. This is what started it all. On one side, you've got the judge calling the lawyer's arguments totally ridiculous and the lawyer himself insolent. Pretty harsh. But then on the other side, you see the lawyer's private letter, and he just turns the temperature way up, using words like loathsome, coward, and fundamentally unjust. This wasn't just a disagreement, it was a verbal brawl that was about to have huge consequences.
And you can see just how quickly this blew up. What started as a private letter on June 21st, well, by July, it's already in the hands of the Quebec bar. That kicks off a whole formal disciplinary process. And fast forward a bit, and by 2006, a disciplinary council finds Doré guilty of misconduct and suspends him for 21 days. So much for being personal. It just got very, very professional.
So this is where it gets really interesting. It's not just about two guys and an angry letter anymore. The case had ballooned into this fundamental showdown, pitting a core Canadian right against the basic rules of the legal profession. And this is the exact tangled mess the Supreme Court had to figure out.
And here's the conflict, boiled right down. On one hand, we've all got the Charter of Rights and Freedoms, which guarantees freedom of expression. Lawyers are citizens too, so they have that right. But, on the other hand, they're part of a profession with a strict code of ethics that demands civility. So, what happens when those two things collide head-on? Which one gives way?
You know, this was a real head-scratcher for the Supreme Court. Their usual test for this stuff, it was built to look at big, broad laws, not these specific one-off decisions made by some administrative body. How could they figure out if one little reprimand was a reasonable limit on a massive charter right? They were going to need a whole new approach.
And that is exactly what they did. The court basically said, you know what? Trying to use our old tools for this new problem is, well, it's an awkward fit. So right there, in this very case, they created a brand new legal framework for Canada.
Think of it like a mechanic's toolbox. The old way, the Oaks test, was like a standard wrench set, great for its main job of reviewing laws, but pretty rigid. The new method, which we now call the Doré framework, is like one of those fancy, adjustable, specialized tools. It's built specifically for looking at individual decisions, and its whole design is about being flexible, looking at the context, and focusing on one key idea, reasonableness.
So how does this new gadget work? It's basically a three-step balancing act. First, you figure out the goal of the professional rule. In this case, it's making sure the public trusts the justice system. Simple enough. Second, you identify the charter right that's being stepped on. Here, freedom of expression. And third, and this is the most important part, you ask, did the final decision balance these two things in a proportional way? Did it limit the right? Sure, but no more than was absolutely necessary to get the job done.
All right, so let's get back to Gilles Doré. Now that the Supreme Court has this shiny new framework, they turn their attention back to that angry letter that started this whole thing. So, how did the disciplinary council's decision actually hold up under this new test? Oh man, this quote from the court's decision, it is just perfect. It nails the balance they were trying to find. The court is basically saying, listen, we need lawyers to speak up, to criticize the system, even to be tough. They're not supposed to be verbal eunuchs. But, and this is a huge but, they have to do it with dignified restraint. Their freedom has limits.
So here's how the court weighed everything up. They said, yep, Dre's right to expression is super important. They even agreed that his anger was justifiable because, hey, the judge's comments were out of line. But then they looked at the actual letter, at the excessive degree of vituperation, which is just a fancy way of saying nasty abusive language, and they said that was not a justifiable response. It just went way too far and damaged the need for civility in the profession. So the bottom line is this. The Supreme Court upheld the original decision. Using its brand new framework, it decided that the reprimand was, in fact, a reasonable and proportional limit on the lawyer's free speech. This wasn't about silencing criticism. It was about drawing a line between criticism and just plain unprofessional insult.
And this is where the story gets so much bigger. Because this new legal test, the one they created just to solve the problem of one angry letter, it didn't just stay in the courtroom. It has created this massive ripple effect across all sorts of agencies that make decisions affecting our day-to-day lives.
And this is exactly why this whole thing matters to you and me. The Doré framework is now the gold standard for checking any decision from a government body that touches on your charter rights. It is a fundamental shift in how power is held in check in Canada, and it protects you in ways you might not even realize.
I mean, just think about what this means. We're talking about parole boards that decide if someone walks free, immigration tribunals deciding a family's future in this country, school boards making decisions about our kids. All of these powerful groups, and a ton more, now have to make sure their decisions properly balance their own goals with your fundamental charter rights.
So the Doré case gives us a legal tool to help answer this question, but it doesn't give us the final answer. It leaves all of us, not just lawyers and judges, with this huge, vital question to think about in our own lives. In a free society, where exactly is that line between necessary criticism and just toxic incivility? And who gets to draw it?